Healthcare is too expensive. Employers are offsetting costs onto their employees. Who will make health benefits affordable for hardworking Americans and their families? You will. This is the Empowering Plans Podcast, a show dedicated to helping you once again emphasize the benefit in benefit plan. Now prepare to learn, plan, save, and protect with the FIA Group.
Welcome to Empowering Plans with the FIA Group. My name is Cindy Merrell. I'm an attorney here at FIA, and I'm today with another attorney who is our resident expert on all things mass tort, Lisa Hill. Her official title is Managing Attorney Sebro Services. Hi, Lisa.
Hey, Cindy. Glad to be doing this with you.
Well, thanks for joining us today, because if I have any questions on any mass tort, Lisa is the first one here at FIA who will know exactly what's going on. Let's start for our listeners. Let's break down when we say mass tort, what are we talking about, Lisa?
Well, we're talking about a mass tort. What we're talking about is an act or omission that harms or injures a large amount of people. So, we're not talking about the one-offs here, or maybe 10 people that get hurt by this. We're talking usually hundreds or even thousands of people that have been injured. And that's what we usually mean by mass tort.
Okay, so typically when we're talking about that, because there's a number of people that are affected by these defective products, typically, what are some of the ways in which, I know I always see on the news, especially with the Camp Lejeune, I see all these advertisements right now for getting people to join these. What are they? How do they pursue these claims?
Right. Well, the two main ways to pursue mass torts are through a class action or what's known as a multi-district litigation. And those are two very different things. First of all, a class action is basically one or a couple of plaintiffs that file suit on behalf of a lot of people. And that means it's one suit with one judge, and all of the decisions take place within that one suit. So once the judgment comes down, it affects everybody that has filed or who is a part of that class action. Now, a lot of those suits are usually limited to economic damages, in the sense that if it's, for example, which we'll talk about this case later, but the CPAP recalls, there are two different cases going on. One involves personal injury and one involves economic damages, where they are reimbursing people who have had to pay outright for their own machines or their replacements, or the new parts kind of thing. And those are the types of actions that would be very suited for a class action, because all the injuries are basically the same. The amount of damages are basically the same for everybody. But the second way that you can do this is what's called multi-district litigation. And that's where everybody's suits are filed individually. So there could be thousands of suits that have been filed all over the country. And what happens is, in order to sort of create some efficiencies within the court system and keep these things moving, they will consolidate some of these suits into one case only for purposes of discovery and pretrial motions. Once that stuff is finished, then they go back into their individual suits. But this way, it sort of helps everybody, in the sense that discovery only has to be done once instead of for thousands of suits that are all over the country. And any motions that are decided, they don't have to be decided in every single court all over the place, which could also result in conflicting opinions. So this sort of helps make that a little bit easier. And the one thing I do really quickly want to mention about that is that multi-district litigation consolidates only those suits that are in federal court. The state court cases are still sort of outside of this.
That's good to clarify, because it can be confusing for many people who are not in the judicial system to understand that we do have state courts, and those are where, if you get a traffic ticket, typically you're going to your state court to go for that ticket. However, the federal claims are typically claims that involve higher dollars or multi-districts, or a plaintiff that is alleging wrongdoing by a defendant that's in another jurisdiction. So typically what we're looking for in those cases are they're high dollar, and these MDLs that are in the federal courts, it makes sense that they would go ahead and consolidate for purposes of discovery. So that way we are reducing the amount we're accessing those courts through the discovery process because they have to make rulings on what is discoverable and those kind of things. Well, thanks for clarifying. So we have MDLs and we have class actions. MDLs are what we're going to refer to are the multi-district litigation and then class actions. So here we are under the mass tort umbrella, and there are several that we have heard about. And one of them I wanted to talk to you about was the Johnson & Johnson talc powder claims. Can you tell me a little bit more about that?
Sure. Johnson & Johnson's has a large number of suits against them involving their talc powder and its possible contamination with asbestos, and that it's causing some serious personal injuries to people, including cancer. Currently, right now, this suit has been ongoing for quite some time, and one of the processes that J&J did within this structure was what's called a Texas two-step.
Ooh, are they out there dancing on the courthouse?
Some might say yes. Anyway, what a Texas two-step is, it's a divisional merger, and it creates two separate legal entities. And what they do is companies will do this, and then they will give one of these entities most of the assets and the continuing business. And they will give the other entity that they create all of the liabilities based on these mass torts. Plus, they will give it some funding or some assets in order to help resolve those liabilities. And then they go ahead and try to file bankruptcy on the entity that has all the liabilities. And
so it sounds like they're trying to avoid payment of any kind of possible findings of fault.
Correct. That is one of the arguments, that what the Texas two-step does is essentially it tracks the costs, and the assets of the solvent company are walled off, and so it creates this much smaller pot of money for injured plaintiffs to draw from. So that is definitely one of the arguments against the Texas two-step. And the other thing that it does is it makes all of these personal injury cases be resolved through the bankruptcy court. That means there is no trial.
Purposes of discovery, it seems that they might not want to be sharing some information that they have.
Right. You know as well as I do that once somebody files for bankruptcy, all suits against them are stayed. They're stopped. People can't proceed with them until the bankruptcy is resolved. And so that way it pushes everybody to resolve it within the bankruptcy. And so people essentially don't get their quote unquote day in court. But now, unfortunately for Johnson & Johnson, when they split up into these two entities, they actually funded the one with the mass tort liabilities, which is called LTL. That's the division that they named it under. They actually financed them pretty well. They gave them basically a line of credit for $61.5 billion, but that was based on the value of the other entity that was created, which is called New Customer. But they didn't cap it there. And so as the value of New Customer goes up, basically that line of credit for this liability section also goes up. So when they went in and tried to file bankruptcy for LTL, the court said, no, you guys are not in financial distress. So therefore, we're rejecting your bankruptcy claims.
Wow.
Yeah, that was a big one. And then J&J went back and tried it again, and the court still said no. So they have twice been denied now in terms of bankruptcy. And the courts have said, okay, that's it. Now these suits have to move forward. And so the other interesting thing that Johnson & Johnson is trying right now is within the 2-year bankruptcy period, when all of this was going on, there was one judge who had been assigned to this case under the MDL, and they had decided all of the motions, including Daubert motions. But during this 2-year time, that judge retired and actually took a job working at a law firm who now represents Johnson & Johnson. But
conflicts?
Yep.
That sounds like a conflict to me.
Yeah. Yep. And a new judge has taken over, and now Johnson & Johnson, where there had been talk of wanting to rehear some of these Daubert motions or put them back up. And the plaintiff's attorneys are going, nuh-uh, this was already all taken care of. And the new judge suggested that the old judge come back in a limited capacity to make these decisions. And the plaintiffs are like, no, are you crazy? Because as you said, conflict.
Yeah. And for our listeners who may not know what a Daubert motion is, can you explain what that is?
Daubert motions are at a certain point within a plaintiff's case, both the plaintiff and the defendant have to list out their experts. Those are the people who are going to basically connect the dots for you. They're going to show how, Johnson & Johnson's talc powder caused this cancer, or what was in it that caused this. And of course, the defense will have their experts to say, no, there is no connection. But these are people who are experts in their field, and most of the time they have very certain standards that have to be met in order to be considered an expert. And so when people go in and go Daubert challenges, they'll try to maybe challenge the manner in which they collected their data, or that their data is off, or they don't have the years of experience to be considered an expert.
So it sounds like Johnson & Johnson's trying to, at this point, take a second run at getting rid of the plaintiff's experts in an attempt to devalue those claims. Is that what I'm understanding?
Yep, that's what's being alleged. And lastly on this, the most recent current status of this is that there has been an $8.9 billion offer by J&J to settle all of the current cases. But now plaintiffs' attorneys are asserting that all of a sudden there are a bunch of quote unquote new members or new potential plaintiffs that have been added, but nobody has filed any cases on these members yet. So nobody knows if these are legitimate plaintiffs or not. And what the plaintiff is saying is that, hey, that can kind of skew the numbers here, because as we'll see when I talk about 3M, sometimes these settlement numbers are based on contingencies attached to it. There might be a certain percentage of plaintiffs that have to agree to this offer before it actually goes into place. And so what plaintiffs' attorneys are saying is if we have all of these quote unquote new signups here, we don't know if they're legitimate or not, they could throw off the numbers by agreeing to this. That way it might discount people who might not want to agree with it, or the other way around.
Right.
One or the other. And so that's currently being looked at as well. So
there's
kind of where we are right now.
Still on that case, It seems to be just going on and on. There's another case that you had mentioned to me before the podcast that sounds very interesting to me. It's against 3M regarding the
ear protection. Earplugs.
Tell me a little bit about that.
Yeah, that one, 3M had a deal with the military and they created earplugs for them. And they were defective. They were too short on one side, which has now caused hundreds of thousands of military personnel that are now deaf or have hearing loss or tinnitus or something of that sort. I think at last check-in, I knew that there were over 230,000 claims filed regarding this.
Wow.
Now that is another one that 3M is another company that did employ the Texas two-step once again, and they created their offshoot was called, I think it's pronounced Aero or Aero, AEARO. And then they tried to bankrupt that one as well. Bankruptcy is still pending, but the plaintiffs are arguing that Aero is not the true debtor here. It's actually 3M. Because unlike Johnson & Johnson, I don't think that they created two new companies. What they did was they created 3M and then they had Aero off to the side. And so there's a question as to whether or not Aero is really responsible for these injuries. It's really 3M. And so that's kind of why their bankruptcy is having trouble. But I can tell you that right now there is a $6.01 billion settlement offer out there.
Wow, that is some serious settlement offer.
Yep, but it is contingent on 98% of the plaintiffs agreeing to it. If 98% don't agree, then 3M can walk away.
That's a very high percentage. I don't even know if my family of 4 can agree at 98% most of the time. But
yeah, exactly. And don't forget that they all also have to take into consideration potential future claims, because there are people who might not yet suffer from hearing loss, but may in the future. And so that also has to be taken into consideration when they're talking about these settlements and how much is going to go to each individual. So, but I think you're right in trying to get 98% of 230,000 people to agree might take a lot of Texas two-step dancing.
Yes. I hadn't really known about that Texas two-step till you mentioned it to me, and that is fascinating. It's a very strategic way to handle some of these situations. So, Lisa, we're both subrogation attorneys, so I'm listening to these numbers, these giant settlement numbers that you're throwing out there. And what does that mean for us here in subro? When we go to subrogate on one of these mass tort cases, what are some considerations we have to think about?
Well, first of all, we're being way down the line, considering we are the subrogation vendor. There's a whole series of individuals that are in front of us who get information. So we're like kind of the last people in the line. It's sometimes difficult for us to get all of the information required to determine whether or not this is a fair settlement and what portion of that settlement our client is allowed to access. Because it starts with the plaintiff's attorneys first. And there might be like a plaintiff steering committee, which is then, just a small group of all the plaintiff's attorneys who are sort of heading this up. And then it sort of rolls through there, and then it can go to lien resolution groups after that point, once they start talking specific numbers. And then it goes to the individuals and their turn, and then it finally comes down to us. And a lot of times when they are making these settlements, they are limiting the treatments that they will pay for, and the amount of time for treatment. They'll also throw in there sometimes if there are lots of other outside mitigating factors. For instance, if somebody develops like asbestos, if somebody develops lung cancer, they'll say, oh, well, this person also smoked for 20 years. Or there might be some other factors that they need to take into consideration, saying that we're not admitting liability here, we're just trying to settle it. So for us, a lot of times, a lot of the claims that we paid, we have to look at, and it's very limited as far as what they're willing to reimburse for medical treatment.
And what's most frustrating sometimes for these plans, and you had already mentioned this, but we're so far removed from the actual injured party. It's typically in a third party liability situation. We're just dealing with the member's attorney who is acting on behalf of the member. This still is true in mass tort. And when we're so far down removed, typically you don't have access to what you would normally have in a settlement amount, as far as we don't have details for medical records.
Right.
Sometimes we do, but most of the time it's more just a number. So they're trying to get that 98% to agree to those numbers, but we're part of that down the line. So
Right.
It's mostly just a numbers game and trying to get the puzzles to all fit. It's not the same approach as you would do in a non-mass tort third-party liability action. So that is something to consider.
Yeah,
all right.
Absolutely.
And on the horizon, when we are looking for the next big news story on these horrible products that can cause some pretty serious injuries, what do you see is the next one we're going to be talking about?
Well, there's lots of scuttlebutt out there right now. First of all, there's a new push to try to link Tylenol with autism. And then there's also the Ozempic and Wegovy, the new weight loss drugs. There are suits being filed because people are suffering from a paralyzed stomach. And that has been sort of up and coming. That might be, I don't think that's an MDL quite yet, but I think that it's getting close to put in there. One of the things that I think is going to be interesting on that one is to see whether or not they separate out people who used it for weight loss rather than diabetes, which is what it was originally marketed for. So I wonder if there's going to be some sort of differentiation there. I think that should be interesting to watch.
Well, good. Lisa, I really appreciate your time. You have given us all sorts of fantastic information, and I feel like I've definitely learned something today. I appreciate you coming on. And once again, Cindy and Lisa with the FIA Group. Thank you.
Okay. Thanks.